Well, again, good evening. I want to introduce you to Ben Merzer, our expert on our legal topic for tonight. Ben, I'm going to turn it over to you, and hopefully everybody here will enjoy the presentation.
Great. Thank you, Charles. Thank you for having me. Again, thank you to the Broward County Medical Association and to the South Florida Hospital News. I really appreciate them doing this for the community. I think our initial objective was 5 years ago was to do these seminars in there with a certain amount of academic integrity so that people can maximize the benefit that they get from it. So with that said, let me get started on the presentation. And here it is. Hopefully you can all see the slide. And I'm going to start the slideshow now. Slideshow from the beginning. Okay. So tonight's topic is how to minimize the risk of malpractice lawsuits. We're going to talk about do's and don'ts of bedside manners, lawsuits, and how to minimize your risk. So as we progress through this, we're going to talk about what to look for when a complaint is headed your way, what to do if there is a marital spousal situation, and hopefully this will help you navigate through that as well. And we're also going to talk about like what happens if a kid comes to you and wants to borrow your car. And that's all about minimizing your risk, not just your malpractice, but tonight's focus is obviously on malpractice. So by way of introductions, let me just give you a little bit about what I've done in the last 30 plus years. My original training is that of an accountant. I went to Florida International University, got a bachelor's in accounting, became a CPA. I worked for a bunch of different places, including LeBlanc and Royal Telecom and FPL Group. So I've been inside large organizations, and I've been inside several different law firms, including Atlas Perlman. I used to have another former law firm with a few other partners. And I've been inside other large organizations like Broward Health and American Medical Depot. And for about the last 4.5 years, I've had my own practice, which is called MIZRA Healthcare Law Partners. And all I do is just healthcare law, along with 3 other attorneys. And that's all we do. So I have a Juris Doctorate with a focus in litigation. I have a LLM of taxation from Villanova University, which I got next after that. And in there, my focus was on mergers and acquisitions and corporate transactions. And then last but not least, my most recent degree was the one from Yale, and it was a Master's of Public Health Administration. It was really about policy. And so I focus on policy because I actually have had a hard time understanding healthcare, as most people do. If you take a look at the logo for our practice, it's actually triangles on top of triangles, and there's a reason for it. It's because each triangle essentially represents how healthcare is perceived from different viewpoints. And if you talk to a physician, they'll say one thing. If you talk to an administrator, they'll say another. And if you talk to a legal person or a compliance person, they'll say another. And it's multi-tiered, and it's got multiple viewpoints going on. So in order to better understand that, that's really why I did my Master's of Public Health, so I could understand the policy reasons behind why things are the way they are. So just so you know, tonight's session is for informational purposes only. It is not legal advice. This is an open seminar. It is being recorded, so if you have a personal question, please hold off till the end and ask your question then. If you have a general question, you are welcome to ask it at any time. I like questions. I welcome questions. And if you don't mind sharing your own personal story, you're welcome to chime in. Just so you know, I don't have any sort of a financial disclosure or relationship that I believe I need to disclose of any sort of undue benefit that I'd be getting from tonight's webinar. But just know that really this webinar comes from the heart, in a sense that I'm really here to just help physicians protect themselves. I just see that there's a big gap between business knowledge of what physicians know and what they don't know. And that's really why Charles and I embarked on this. That's why Cynthia Peterson from the BCMA is all for this, and we've got a pretty good community support. And this is actually a fairly this is a growing program. Tonight's presentation is going to be about do's and don'ts of bedside. We're going to talk a little bit about disciplinary complaints, because I think that the professionalism and the licensure really plays hand in hand with how bedside manners occur, as well as medical malpractice lawsuits happen. And then last but not least, stick around, because we're going to talk about how to protect your assets. And there are ways, we're going to talk about ways of how you can protect your assets for, essentially for free. Basically, just understanding the basic blocking and tackling of how do you own certain forms of property, and how do you protect them. And we'll even talk a little bit about on the complex side of things as to how do you go about using more complex vehicles for asset protection. In the end, we should have about 5 minutes left, but I am going to talk a little bit fast as we go through tonight. So let's start off with the first question. Why are we really even here? What can possibly make me liable for anything, right? So that's where the question begins. When you're looking at exposure, you've got several places where you can have exposure come to you. One is you could be exposed because you've got vehicles, and obviously vehicle insurance really does help a lot with that. You've got properties or real estate. It could even be office properties. When visitors come on the property, they could potentially get hurt. Then there's also family members, like we mentioned a little while ago. We talked about how what would happen if a kid borrows your car and then gets into an accident, right? How do you deal with that? Also, an often overlooked exposure of liability is boards of organizations or business misunderstandings. So, like, for example, if somebody comes to me and asks me to be on their board, one of my very first questions is going to be, do you guys have directors and officers insurance? If they don't have directors and officers insurance, I'm not so sure I want to be on any board that I am not insured to be on. And I want them to cover that, because I don't know where claims can come from. So we're going to talk about things like this a little bit more. And then near and dear to all of our hearts is really your professional license. If somebody loses money, oops, that's actually the wrong slide for this one, sorry. But actually, if somebody somebody suffers undue consequences from a drug, if somebody is treated improperly in your clinic, if somebody's information gets out, what are the actual professional liabilities having to do with that? And I think you have to take a look at that pretty closely and understand what your obligations are. And then as we talk tonight, I want you to eyeball your patient's consents. I want you to take a look at them and see what your patient consents are consenting to. And I want you to take a look at your release and waiver forms. And hopefully when you walk out of here, you'll have a totally different perspective on that. One of the things is we often have forms filled out at the time that there is a patient intake. You may want to take a look at those forms. The other thing that you may want to look at is all of the forms that a patient fills out before they go into some sort of a procedure or some sort of a high risk sort of a scenario. And I think you want to take a look at those forms as well. These are really the sources of where your liability and exposure will come from. So again, your professional licenses is probably one of the biggest things. And we're going to talk about that in some pretty good detail coming up. So what is expected from physicians? Well, there are daily challenges. When you're a physician, there are daily challenges. And here's some basic ethical rules that you guys have to follow, including lawyers. And we have much the similar sort of stuff. You have to be essentially altruistic. We have to be, as lawyers, we have to be advocates, right? You have to be the advocate of your patient's health. The next thing is you really can't have a financial interest in any sort of undue procedures that patients may be facing, right? So remember, keep in mind, you can't have referrals, and you can't have unnecessary testing and billing of things, and you can't do fee splitting, and your gifts that you give each other have to be within check. And also there's just no kickbacks allowed between organizations for referring any kind of patients. Sale of products, investments, and loans, those are usually hidden ways that things can happen and financial interests are exchanged. So you have to, so as an attorney who's worked inside healthcare systems, I look at sale of products, investments, and loans with a very different eye. I look at them as to how legitimate and valid and proper they are, and how within market those things might be. Also, keep in mind, as a professional, you cannot have personal interests like such as sexual activity, no undue influence over your patients, and also alcohol and drugs are are also a big no-no. What I do know is that the Board of Medicine and the Board of Dentistry, I happen to sit on the Board of Dentistry. If there's any sort of sexual activity between a professional and their patient, they actually fast track those sorts of complaints. And so be mindful of anyone that is involved in anything personal like that with a patient. It is a big no-no. And that can lead to other points of exposure. As professionals, you are also required to report others who are violating their ethical duties. So just keep that in mind. So, what are the do's and don'ts of bedside manners? Professionalism and protection of assets go hand in hand. And as we go through this, you'll see what I mean. So when you talk to a patient, how do you talk to them? Do you talk to them at eye level? Do you talk to them as if they are your friend? Do you talk to them with real interest, or do you talk down to them? And this might be something you want to assess about yourself, about each other, your colleagues, and really, and how you talk with a patient makes a big difference, and how frank you are with them as well, and how clear you are. It makes a difference as to how believable, likable, and so forth you are. In this cartoon here, it says, "I hate doctors," and then the doctor says, "I'm happy to see you too." Essentially, as doctors, you guys have a different level of obligation, and it goes beyond looking beyond the patient in and of themselves, no matter what condition they come in. Also, keep in mind, you've got infection control you have to keep in check. No touching of like your ties, your pens, phones, iPads, and tablets, because all of that sort of stuff, if you're touching them and you're touching the patient, and are you transferring anything back and forth, keep those sorts of things in mind. That's why I think most doctors don't even wear ties, because ties are obviously another thing that gets in the way. And remember to use a team approach when it comes to patients. Always have a game face in front of the curtain versus taking corrective action behind the curtain. So what I mean by that is, if something doesn't quite go right in the office, don't have that discussion about how things didn't go right in front of a patient. Have it when the patient is actually gone. So you can have a true heart-to-heart with your staff of what went right and what went wrong. And because disciplining somebody in front of a patient is also a pretty bad thing. It counts against you. It's unprofessional, and it lets those who are listening know like what went wrong, and it opens you up to another point of exposure or liability. Now, patient and physician relationships, keep that in mind. They are confidential. And when you're treating families, this really plays an important role. You might be treating a mother and an adult daughter, or father, son, cousins, so forth, right? And so those kinds of relationships, I think physicians often happen to overlook, and they start to talk about the one relative to the other relative and how their health is doing. So just be careful of that. Be approachable, listen to a patient's problems, and I think you're going to be a lot more liked. Review a patient history and their charts ahead of time before they walk in. Take timely notes, because the more timely notes you take, it increases the accuracy of what you're writing down. And be careful about cutting and pasting anything, because cutting and pasting can actually run you into problems, because you may not be writing the exact correct thing as to what occurred during that patient encounter. Now, When you give drugs, make sure you give an explanation. You give them the purpose and the potential adverse effects that you've noticed before. At the front desk, your team begins at the front desk to your medical assistant, the MA, and over to you as the physician. So keep in mind you have a team approach. Money, copays, and financial responsibility. If there's not enough clarity on that, that is going to count against you, and that can be problematic. And it's often the source of problems like licensure complaints later on. Do keep in mind that if a patient threatens you or your staff with violence or with lawsuits, you got to keep those kinds of things in check. If a patient even makes threats over the phone or comes into your office and makes any threats of violence, I think you've got to seriously consider firing that patient. Same thing with lawsuits. If somebody is actually threatening a physician or your office with lawsuits, you got to reconsider as to why do you even have them as a patient? Because there's obviously a reason. Either they don't think you're right for them, or that patient is not right for you. So what I say is fire the patient. If you need a template, I do have a template letter on my website. You might want to take a picture of this. It's at MIZRAHealthLaws.com/sample patient termination or discharge letter. If you go to that page, you'll see it. And it's an easy copy and paste, and you can just make that a part of your repertoire of how you terminate a patient. And remember to give them a 30-day notice. That's what the state of Florida requires. So you got to give them a 30-day notice. And if they have an appointment coming back to you on the 25th day, you need to go and see them. You still need to see them. Now, the other thing you may want to consider, I like the way I spelled GETA. GETA website. One of the things that physicians often overlook is the need to get their own website put together, the need to have their own Google reviews put together. We touch a lot on this in the non-compete seminar that we do. But that is really a building block in your career path. The more online presence you have, the more of a website that you have, the more engaging it is, the more questions that it answers, the more likely you are to pick up, patients, make your presence known in the world. Any questions? Yeah, so you may want to develop a personal page even on LinkedIn and on Facebook. Ask patients for reviews and ask them to actually give you a Google review. It's really easy. If you actually just email someone with the exact link of where they need to go, and you just tell them, hey, can you give me a Google review? You'd be surprised how many physicians have like less than 10 reviews. Most physicians barely have like a handful. So build your own presence. It's going to help you a lot out of your way through life, through career paths, and even through building presence online and bringing in new patients. So what happens if you don't do the do's and don'ts and you don't follow those do's and don'ts? How does a licensure complaint get filed? So who can actually file a licensure complaint against you? It could be a patient, it could be a disgruntled employee, it could be other physicians, it could even be a competitor. It could even start from an enforcement perspective or a self-reporting perspective. You can even file a complaint against yourself. I forget scenarios at this point in time, but yeah, there are things that you've got to take a look at, and self-reporting is a part of it. So, for example, if you happen to be involved in some sort of a criminal prosecution, for example, a DUI, if you get prosecuted of a DUI, even if you plead no contest to it, you still have to do self-reporting for it. So that's how complaints start against the license. But some of the most common complaints that the health department sees is not updating your profile. Just make sure that your profile is updated. Anytime you make a change, it's got to be updated within 30 days. So you've got to update your own profile. Anytime that a patient asks you for medical records, do give it to them. Don't hold them back, because that can be another source of complaint. It usually does not rise to the level of where it gets opined upon by the board of medicine. However, you don't want to have investigators calling you up and asking you questions and so forth. Now, if there are adverse incidents, those are also reportable. Just know which adverse events are reportable. And sexual misconduct is another thing that's a big no-no, and it gets reported quite often. Among these disciplinary complaints, illegal prescriptions is another part. Practitioner profiles not being up. I misspoke earlier. Practitioner profiles need to be updated within 15 days, not 30 days, like I spoke earlier. Violation of advertising rules is another thing that can happen. So before you advertise anything, know your advertising rules. Like, for example, you can't overpromise results. You can only, the ads have to be truthful and matter of fact. But there are specific advertising rules that apply to physicians. You do have to report wrong site surgeries and procedures. If you are moving or closing your office, you've got to report those. And then also keep in mind your patient boundaries. Your patient boundaries, you got to steer clear of the personal issues between what it can happen between a physician and a patient. Now, once a complaint is filed, the investigator will typically look at the legal sufficiency of that complaint. What they'll look at is it in writing? Is it signed off by a person? And does it allege sufficient facts that would result in a violation of some sort of a rule or law? And particularly rules of ethics. So if the facts are not sufficient enough, the investigator will generally just dismiss that complaint right then and there. However, if there are sufficient facts, the investigator will often ask for further documentation. So then you'll get a request in the office, and then you've got to provide those sorts of records. So the first part of any complaint is, does it pass the muster? Get the joke on the screen? Muster? Get it? Muster? Okay. And if you do have a complaint that's ever filed against you, it's going to follow this path. This path is found on the Division of Medical Quality Assurance's website, and it's pretty easy to follow. But I've drawn some red markings on here. Note where this arrow is right here is where the complaint comes in. It comes in, it gets analyzed, and it gets either disposed of because there's not enough facts in it, or it gets moved along. And if it gets moved along, it usually means it's going to an investigation. It's going to go through an investigation phase. Somebody's going to look at it. And if there are enough facts in that complaint and enough supporting documentation and evidence, it gets moved along to actually prosecution. Then the prosecuting attorneys get to review the complaint, and then it goes before what's called a probable cause panel. Now, all along this whole northern part of this diagram is confidential. But once an actual case has been filed against you or against the professional, then it becomes public. Once there is an administrative complaint filed, it becomes public, and then you go through that whole due process. So that's how complaints work. Oftentimes, these complaints, the reason why I talk about them here at length is because I want you to know that sometimes patients are testing their legal theories to see if you've got medical malpractice issues that can get vetted through this whole licensing complaint process. And if they can, they're going to go to an attorney that does medical malpractice lawsuits. So how to know when a lawsuit is coming? Well, one of the things that we just talked about is if someone files a complaint against a physician, that's a possibility. Also know that there are threats that if a patient is making, do take those threats seriously. Don't take them lightly. If a lawyer is requesting for the physician to meet with them, that's another, hint that there might be something coming up, but not necessarily. It could sometimes just be a simple question, Q&A. Uh, Also know that if somebody is asking for medical records or the types of medical records that they're asking for, sometimes you may be able to tell from that, but asking for medical records is a very typical thing. It's not abnormal to ask for medical records. But at times, if all of these things start to kind of gel together, that's when your ears should go up and you should start thinking about it a little bit more. Uh, Now, if a complaint is filed against a physician's license, that could also be the first testing ground of how um, the how strong that patient's complaint is. And if you receive a letter of intent to sue, then you definitely know that, right? So that's definitely a sign that there may be a medical malpractice claim coming. Now, when medical malpractice claims come, what are they? What sorts of medical malpractice claims are there? So the kinds of medical malpractice lawsuits that exist usually result from not being able to, from physicians not responding to patient requests, not responding to emergency calls, or misdiagnosing or missing a diagnosis, right? So misdiagnosing or missing a diagnosis, meaning like not reading the charts, not reading the diagnostic tests, failure to read the notes, lack of documentation also gets physicians in trouble. And infections and contaminations could be another thing that could cause negligence claims. People will often ask me, how long does a lawsuit take? Well, lawsuits can really vary as to how long they do take. And what'll generally happen is, if you look at this chart here this is an illustration, like a timeline illustration. The stuff that you see in this pinkish sort of a color, these are like the pre-suit demand letters that attorneys will typically send out. And so that's when the process kind of begins, right? It really begins with those pre-suit demand letters. And then you have all of these steps that the lawsuit goes through. So if you ever have a question as to how far along a particular malpractice lawsuit is, just kind of pull this out and use this like a checklist. It should almost follow this sort of a timeline. And if you have an attorney working on that malpractice lawsuit, helping defend or whatever, you know the kinds of questions you can ask just by looking at this. So, like, for example, here's where it talks about preparing a lawsuit, serving a lawsuit, tackling preliminary motions. But all the way down here at the end, it talks about attending trial, filing, obtaining a final judgment at trial, and maybe even filing appeals. So as you go through this process, it talks about what sorts of discovery motions there might be, what sorts of discovery requests you can expect. So whenever there's a lawsuit, this is the kind of heartache that some people have to go through in order to get their lawsuit seen all the way through the system and the process. Now, what are the do's and don'ts after a receipt of legal papers? If there is a intent to sue or a complaint, you've got to now notify your corporate risk management folks, and you should notify your insurance company or the insurance agent that you have. And if you're self-insured, you're going to have to go out and hire your own attorney. Now, according to your insurance company, you are entitled to a legal counsel, and they will pay for the cost of defense. I don't do any of that work, but what I do is I do help physicians personally think through what's going on in their malpractice lawsuit, and I work with the malpractice defense attorneys to make sure that they've beefed up the defenses sufficiently. Now, when I do that, the insurance counsel does 90% of the work. I do maybe 10% of the work, and I usually just make sure that things are going the right way, and I make sure that my physicians get out of the lawsuit as quickly as possible, so they're no longer named in it personally. Now, let's talk about assets. This is the part that you've all been waiting for, and this is where I'm actually going to slow down a little bit and talk about it in detail. What is asset protection? Well, it's an adoption of strategies to guard one's wealth. And your license is one of those things. Guarding your license is probably just as important as guarding your wealth. Because if there is no license, I'm not so sure that the wealth will always be there. What asset protection is not is that it is not about concealment or hiding of assets. It's not about doing some sort of a contemptuous act to hide your stuff. It's not about tax evasion. It's not about bankruptcy. It's about preventing others from attacking your assets. Now, what level of asset protection is needed? Well, there is what's considered a low level of net worth, a high level of net worth, but really it kind of depends. When I say low level of net worth, that's really the world that most people live in. Most of us probably have a value of less than $10 million. And is 10 million really your cutoff between high and low? I'm not so sure. It could even be 5 million, or it could even be 2 million, depending on how risk averse someone is, and what's the likelihood that they might get attacked by a creditor. So as we talked about this earlier, these are your sources of liability. Keep those in mind. And so now let's talk about asset protection techniques. Before we start talking about that, keep in mind that Florida has a Florida Fraudulent Transfer Act. It does not allow for anyone to transfer their assets within 4 years of when a claimant has knowledge of a lawsuit that's coming. So what that basically means is, if someone knows that a lawsuit is coming or a creditor is coming for them, you cannot just go about moving your assets just to hide them, especially within the 1 year mark of knowing that. Now, if it's 2 years out, 3 years out, or 4 years out, it gets more and more into the distance. If it's past the 4 year mark, it's not going to be considered a fraudulent transfer. But if it's within a 4 year mark, it could be fair game. If it's within the 1 year mark, it again could be fair game. That doesn't mean you don't transfer assets if you know that a lawsuit is coming. It just means that it might be fair game for creditors to chase you for it. When you are looking for asset protection, think of a house that's built of twigs. Think of a house that's built of bricks. To what degree do you want to protect yourself? If you build a house with twigs, it's cheaper, it's faster, it's easier. Just like if you're riding a bike versus a Mercedes or a tank. If you build a house that's built of bricks, it takes more time, it takes more energy, it takes more cost, and it just takes overall much more time to build. So today, what I'm hoping to help you get is something in the middle. You're not going to get a bike. You're not going to get a Mercedes or a tank. What you're going to get is a Toyota Corolla, and something that's fast, efficient, reasonably cheap. And those are the techniques we're going to talk about next. So let's go. You guys may already be aware of this, but if you're not, you really should be. There are 3 things that can work to your advantage in Florida. Number 1, there is a Florida homestead. If you don't know much about Florida homestead, I suggest that you Google it. But there are statutory protections that creditors cannot attack your home, your homestead, if it's homesteaded, and you've got to file homesteading notices. Also know that life insurance policies are protected as well. Creditors cannot go after your life insurance policy. So if you have money sitting in a life insurance policy, it's protected. Retirement plans, same thing with IRAs and 401ks. They also have an exception. Creditors cannot go after your retirement plans or your IRAs. But what about all of your other investments, like ownership of businesses, bank accounts, properties, cars, stocks, bonds? How do you maintain them, and how are you going to preserve them? So let's start off with some simple techniques. here are some simple techniques that I think everyone should be aware of. Okay, and these are the kind of techniques that you use on a day-to-day basis, in the sense that each time you buy an asset, like for example a car or a house, or open up a bank account, or even for liability purposes, if you're starting up if you're getting a mortgage, you know, how do you name those sorts of assets? So remember, you've got the Florida homestead protection that we just talked about. You've got the retirement accounts and the life insurance policies where you can actually sock away money and have it be protected. And also, there's something that's called a spousal privilege. So if you have a spousal privilege, if you have a spouse, if you have your name on an asset where it's you and your house, you and your spouse showing up as husband and wife, then what happens is that double name on a piece of paper literally means a third person. It takes on it's not exactly legal, but it's almost treated as like a new person that's created between the husband and the wife. It's like a new legal entity. So if the husband does something that creates a liability, and you have a joint property like that, a creditor can't go after it. If the same thing, if a wife does something but the husband was not responsible for it, then still a creditor can't go after it. So there is a spousal privilege that's in play, and you should be aware of that. And there are ways to name your assets that way. If you ever have any questions as you're putting your names on your house or your car or your accounts, you're welcome to call me and I'll happily walk you through it. Now, I want you to be aware of two types of naming conventions. One is tenants by the entirety, and the other one is joint tenants with the rights of survivorship. These are the two most common account types that are held by people to protect it from creditors. So if you're married, you're going to do what's called tenants by the entirety. So like if you go and open up a bank account, you're going to make sure that you check the mark about tenants by the entirety. If you go to a bank and you happen to open up a account with your brother or your sister, you're going to mark off joint tenants with the rights of survivorship. And the reason why I say that is because this will help you pass on your asset without having to go through probate. This will also protect you from outside attacks, because now you have another person's name on there. Now, simultaneously, keep in mind, if the other person's name is on there, that could also open it up to more attacks that they might bring on. So always be careful if you happen to put somebody else's name on an account or on an asset, that they don't have people chasing them. If they have creditors chasing them, think twice. You may want to consult your asset protection planning attorney to help you think through that as to how you would name that particular asset. Now, insurance. There is, insurance is the ultimate protection in a lot of ways. You can buy insurance for just about anything, and getting insurance to help you protect your assets and having enough of it will really, help you avoid 90% of the possible things that can come up. So that's another way to avoid that. But again, insurance is an expensive proposition, and it takes time. So insurance is another avenue. We're going to talk a little bit about going bare, that can help you save money, perhaps thousands, but there's also a downside to it. But hold on to that, and we'll get to that in just a few minutes. So that's why I think it's important for those of you that are practitioners in the area and are thinking about going bare, sit tight and we'll talk about it. Now let's talk about, what do high net worth individuals do? Well, what they do is they use more complex tools. They will often hide their assets under different names, and they will use land trusts, they will use corporations, they will use regular trusts, they will use irrevocable trusts and revocable trusts. There's actually different kinds of trusts that can be put into place. And also, high net worth individuals also look keenly upon prenups, and you may want to consider that. And the prenups really come into effect when you know that one spouse has or will have significantly more assets than the other spouse. But if both spouses are going to have about the same, whether it's through inheritance or through work or through earnings or whatever they have as a special talent, and they're about the same, then obviously the prenups become less important. But if it's all a wild card and one spouse has a significantly higher amount of assets, you may want to think about a prenup. So that's another way to protect yourself from a spouse in case if something goes wrong. Now, what rich people will do is they will often layer the assets with debt. They will, meaning, for example, they will take, let's say they buy a house and they want to buy it for cash, but it's going to be used as a rental property. So what they'll often do is they will have another company, they'll create another company that lends the money to buy that house, and it actually creates a mortgage on that house. So it's no longer a paid off house that's being rented out. It's actually a mortgaged house that has a mortgage on it. So that way it's not a free floating sitting there, sitting duck that's ready to get attacked by a creditor. There's an actual debt on it. So that's another creative way to preserve wealth, is by creating debt at the same time. Now, you can layer it with holding companies and operating companies, just like in that scenario that I talked about with the house and the debt. You would actually have multiple companies. You'd have the one company that owns the house, and you'd have another company that does the lending. So you'd have two different companies. Now, the only way you can make this legit is to make sure that you keep all of your books separated, the accounting of it separated. Make sure that your accountant is also following the rules. Make sure you separate your bank accounts. Otherwise, if it all starts to look like it's coming out of the same bank account, then it starts to look more and more like it's the same one entity. And if that happens, then there's what's called piercing the corporate veil. And, a talented attorney could pretty much go right through it and say that the two entities are one and the same. So make sure that if you're using this asset technique or multi-trust or multi-corporation techniques of protecting your assets, that you do pay attention to your accounting. Your accounting must be maintained in separate accounts. Now, other people will also move assets to a different country to preserve it, so it's less, so it's not on the radar as much anymore. But you got to be careful. You got to make sure that you disclose it. You file your tax returns, and you disclose it properly in that. Another interesting technique to preserve assets is by holding it in companies, and in the operating agreement, you put in what's called a poison pill. And in the poison pill, you could put in like golden handcuffs. You could put in voting versus non-voting shares. You could actually have penalties for someone who gets attacked by an outside creditor, meaning that they lose all of their rights in that company. Things like that. You can actually create poison pills that go into an operating agreement of a company. And that's how this is the more complex side. This will usually cost you some sort of legal fees to get there. However, this other page that I had just touched on earlier, these are all pretty much quasi-free techniques that you can use to protect yourself. Now, most normal people will use this along with maybe a company and maybe a trust, something like that. That's what they'll usually use. But as they get richer, the more trusts and more companies that will be formed. Any questions so far? Okay. So now let's talk a little bit about Florida tort reform before we go into going bare. Does Florida tort reform provide protection? Yes, it does. It does provide protection, but it provides protection as to non-economic damages, which are limited to $500,000, and it could be up to $1 million in catastrophic cases. So what that means is non-economic damages. So like mental anguishment, like impairment to someone's reputation, things like that. The non-economic damages or pain and suffering, above and beyond their ability to operate and needing all of the other actual economic damage, actual economic help is considered non-economic damages. So that's limited to $500,000. However, there is no limitation as to actual economic damage. So if someone gets hurt and they were, let's say, I don't know, working as a rocket scientist and making $1 million a year, if they can no longer work as a rocket scientist and now all they can do is really just, let's say, be a bookkeeper, then what's going to happen is that that differential in value is an actual economic damage. So there is no protection for actual economic damage. And here I lay out a bunch of different examples of what kinds of things are considered actual economic damages. But just, also know that in March 2023, there was a House Bill 837, and it was passed through the Florida legislature, and it made it law that the statute of limitations has been reduced for negligence from 4 years to 2 years. So that may very well play into all the future things that happen in our lives as they pertain to malpractice, negligence, and risk and liability. All right. So now this is my last slide, and we're going to talk about insurer or to self-insure. As you know, or if you don't, you should know that physicians are required to maintain $300,000 worth of insurance coverage if they are working outside of a hospital system. But if they're working inside a hospital system, they have to carry coverage of $257.50 if they are inside a hospital. So most hospitals will require that the physician sign off on something like this, or that they sign off on some sort of an exemption form. So these are the minimum requirements up here as to what's required from insurance. Now, that's not to say that you can't get around it. You can get around it by going bare. The way you go bare is by saying either A, that you're exempt from it because you've been practicing over 15 years and that you're seeing less than 1,000 hours worth of clinical work a year. And there's actually a whole criteria to it, and I've got the form for it. If you need it, I can send it to you easily. Just email me. But in your practice, you will have to display a sign that shows that you have no insurance. And it's also best to actually get a patient to sign an acknowledgement that they know that you don't have any insurance. If you're going to go down the road of going bare, meaning without insurance, it's important to know that now you would, if a lawsuit was filed against you, you would be the one that would have to come up with the actual cash settlement that it would take to settle out that lawsuit. Now, as statisticians also know, that if you do happen to go bare, you're less likely to get sued for malpractice. But if it does happen, it's coming out of your personal pocket. So should you go bare? Should you not go bare? You've got to really take a look at your cost of coverage. You've got to take a look at the assets you're trying to protect. You've got to take a look at your discretionary net worth. You've got to take a look at your prepaid litigation defenses, if there is such a thing. And then you've got to take a look at settlements and how those are reported. So a couple of suggestions for you would be, number one, if you have your own practice, put it under a corporation name, and try not to make the corporation name your own name. Try to give it like some other name, like Banyan Tree Medical, or whatever you want to call it. You can call it company ABC Medical, whatever you want. But just try not to name it with your own name, because then it just becomes a little too readily apparent that it is you attached to that corporation. And it makes a few other things that lawyers like me try to do a little harder, because then we can't help you as much. Now, all settlements that you have in a medical malpractice lawsuit will get reported to the NPDB. So the way to get out of being reported to the NPDB is to make sure that you are extracted from that lawsuit and the lawsuit is dropped against you, which is why people will often bring me into their medical malpractice lawsuit and help them oversee it, is so that they can get extracted out of that lawsuit easier, quicker, cleaner. So that's pretty much all I have for today. If you have any questions, we can take them at this time. We can take some for recording, or we can take some for non-recording. If you have any questions while the recording is on that you think are worth talking about, this is probably a good time to talk about.
Ben, I have one question for you.
Sure.
When a physician receives a letter from the Department of Health, obviously, usually precipitated by a patient complaint, what should they do?
Well, number one, to examine all the facts with a critical eye as to what a third person would look at it. I would probably bring in another colleague and have them look at it with you. If there is actual exposure there, you might want to retain an attorney. But if there is no exposure and you're pretty certain of that, you got to be really certain about it before you submit all of this stuff over to the state, to the Department of Health. If you're pretty certain about it, then go ahead and do it. But if you're not certain about it and you think you've got exposure, something did not go right, or that something more could be made up of it, then I suggest that you get an attorney involved. I take care of those sorts of complaints. I have a colleague that's even better than I, and I usually have that my colleague Monica work on it. So yeah, that's how we do things. So, well, by the way, are we still recording?
Yes, we are. I'm going to shut off in just a second.
Okay, sure.
All right. Let me go ahead and